federal court has just affirmed all that hard evidence. It proves that the White House, the Department of Justice, and the FBI, among other agencies, threatened and coerced the social media platforms to censor and suppress disfavored viewpoints and conservatives' social media posts online. I'm grateful we have with us today two individuals, Mr. Kennedy and Ms. Harris, who are directly impacted by that censorship, and the third, Mr. Sauer, who we're about to speak with, serving as lead counsel in the landmark lawsuit against the federal government on this issue. Let's talk facts. The American people are not aware of the magnitude of this case, Mr. Sauer, and its profound implications because most of the mainstream media is in on it too, and they're trying to bury the story. In brief, in May of last year, the attorneys general of my state, Louisiana, and the state of Missouri filed suit in U.S. District Court of the Western District of Louisiana. This blatant censorship. They went after the blatant censorship by the Biden White House in 9 of its federal agencies. 2 weeks ago on Independence Day, the district court issued a truly extraordinary 155-page court opinion, a ruling granting the plaintiff's request for preliminary injunction. Mr. Sauer, your lead counsel in that litigation. You referenced some in your opening statement, but let's do it again here because they don't seem to be paying attention. Can you give a summary again of some of the key components of that opinion and the basis for it? I know you mentioned there were 82 pages of detailed factual findings, right?
That is correct. 82 pages, 577 citations of the record evidence. That evidence is drawn from about 20,000 pages of the government's own communications with social media platforms and 6 full-length depositions of senior federal officials with firsthand knowledge of federal censorship practices.
It's absolutely staggering. And now they've tried to bury this and say, well, the Fifth Circuit entered a temporary administrative stay. They granted an expedited briefing and oral argument, however, for August 10th. What's the impact of that? Isn't that routine practice in the Fifth Circuit?
That's a direct quote from the recent Fifth Circuit decision, N. Ray Abbott, which is cited in my written testimony. It's legally incorrect, clearly legally incorrect to describe them as vacating the injunction, which has happened multiple times.
They either don't know the law or, I don't know, they're trying to obscure the facts. That's a theme around here. The White House and the fellow Democrats disputed almost none of the factual findings in the court. Isn't that right?
So far, we've had 2 emergency stay motions from the Department of Justice, one in the district court, one in the Court of Appeals. And what really struck me in reading those is they just don't dispute those 82 pages of factual findings. Almost none of them are directly disputed in what they've filed so far.
So at the very beginning of this lengthy opinion, the court explains the staggering scope of the government censorship uncovered here. At page 2, the court explains, quote, if the allegations made by the plaintiffs are true,